So good morning, everybody. It's 11:30 and let's get started. I'm Jeff Rosen. I'm one of the lawyers here at Cunningham Legal, and I'm joined by Jim Cunningham. Hey, Jim, how are you?
Hey, Jeff, how's it going? Good to see you.
It's going great, and I thank all of you for joining us today. So we're going to do a virtual workshop. Our topic is going to be protecting an inheritance from divorce, lawsuits, and bankruptcy. And I'm incredibly excited about this topic. This is something that so many of the clients that we work with come in and they say, hey, I'm really concerned about two things. I'm concerned about protecting my own assets, but I'm also concerned about what happens after I'm gone and I leave all this wealth I've worked a lifetime to accumulate to my loved ones. How do I ensure that those assets remain protected for them once I'm gone? And that's what we're mainly going to be focused on today. And so I'm thrilled that you've all joined us. I'm so happy we have Jim here, who is an expert in this field of law. And I need to start off by putting this disclaimer up here. So I am a lawyer, Jim's a lawyer, and we're talking about legal stuff, but this is for educational purposes. So I don't want you to construe what we're doing today as giving you particular legal advice. We're talking about legal concepts, but the purpose of this meeting is to really look at things from a 30,000-foot view and really get the brain juices flowing. Now, we're talking about asset protection today. And interestingly, if you look at our website, if you look at our Facebook, you don't see a lot of advertising for asset protection. And that's the case with a lot of law firms that specialize in asset protection, is that we're not really broadcasting it to the world that we're experts in it. And the reason for that is one day, if someone we've helped accomplish this level of asset protection, this great structure, if they're getting sued one day, if they have a creditor issue, we don't want the information on our website to be used against them. And Jim, we've actually seen that be done before, right?
It's interesting because there's an attorney in San Diego, very well-known asset protection lawyer, did his own asset protection plan. And in the trial against him, they took his whole website and took clips of the website and put it up on a big screen for the jury to see, saying, hey, this guy's just trying to evade creditors. So asset protection is one of those things that you don't really put on your website. You don't really talk about it a whole lot in the ether, but it's done one-on-one with the client.
Yeah, absolutely. So it's a little interesting when you look at that. But legal advice is what happens, guys, when you sit down and you have a video conference with a lawyer, you have a phone call with a lawyer, and we have a chance to kind of get to know you a little bit better on an individual basis. And so speaking of legal advice, what we're offering all of you for attending today is the opportunity at the end of this to schedule a free consultation, no obligation, with one of the attorneys. It could be me or Jim or one of the other 5 attorneys that practice here at the firm, where we can deliver you some specific legal advice. It's a fantastic opportunity. So we have 7 lawyers here at the firm. So you can see I'm on the far right, Jim's on the far left. And we are not what you would consider general practitioners. We are all lawyers who specialize their focus, their practice area, to this realm of the law. So we are trust lawyers, estate planning, trust administration. That's our wheelhouse. So we're not doing divorce law in the morning. We're not doing personal injury in the afternoon, sprinkled in with a little bit of estate planning law and asset protection law. This is our niche practice, and we're all very well versed in this area of law. So why are you here today, right? Why have you devoted your valuable time to watching Jim and I today? Well, I would imagine if you're like a lot of the people who I meet with, you worked a lifetime to accumulate your wealth. Whether you've accumulated a lot of it or a little bit of it, I have no doubt that you worked very hard to accumulate that. And I would also imagine that you're a very caring person, right? If you weren't a caring person, you probably wouldn't have joined us today. And here's the thing that I like to say, and I'm a little disappointed by it, but if you've been paying attention to the way society's been shifting over the last 10 years or so, unfortunately, risks are becoming greater. I think there's a higher probability today than there was 10 or 15 years ago that someone we love may have a creditor issue one day. They may get sued, and they may get sued for something that they're not even responsible for. They just were in the wrong place at the wrong time, and they got named as a defendant. What's more popular than ever right now? Divorce, right? And these risks have become increased. And I think what you see when these things change in society, the strategies we use in estate planning kind of change alongside it. And so that's why you're here today, to figure out how to wrap your head around this and how to protect your loved ones. Because I think when you think about estate planning in general, the reason we do this in the first place is to protect ourselves, but we're really doing it to protect our loved ones, right? So let's focus on that. How do you protect your loved ones from a future lawsuit, from a future bankruptcy, from a future divorce scenario? That's what we're going to be looking at today. And I really think it's helpful to view this from two perspectives. So you can kind of look at it from the perspective of how are you going to structure a plan to accomplish this? And then you also need to look at the different types of assets that somebody may have, because the plan you set up may be particular to the type of asset you have. So I meet with people all the time who say, well, Jeff, I have a house, I have an investment account, I have an IRA, I have an annuity, and I don't really know how all these work in connection with each other. Can I set up an asset protection plan for all of these assets or just some of them? So that's how we've kind of organized our presentation today. Now, when it comes to the structure of the plan, I think traditionally what's been done for years and years is people will set up a trust where they design the inheritance to go to their loved ones as what we call an outright distribution. And you can think of an outright distribution as basically meaning, hey, we're going to take your inheritance and it belongs to you. We're going to stuff it in your pockets, whether you want it or not, right? You are the outright owner of these inherited assets. And so, traditionally when you think of an inheritance, I think that's what a lot of people think about. But what's the problem with that? What's the problem if the beneficiary, the one who's inheriting all this wealth, but what if they're going through a lawsuit at that time? What if they're in the middle of a divorce? What if they're planning on filing bankruptcy soon because COVID-19 wiped out their business and they just couldn't stay afloat? That's problematic, right? And how do you solve that problem? What's the option you may want to consider to not leave your loved one in a position like that? Well, you can give them the gift of protection. You can set up a trust. You can use the principles of trust planning to protect that wealth that you've worked a lifetime for when it transfers to your loved ones.
Yeah, it's been said, Jeff, it's been said that if you love someone, you'll never leave them anything. So if you love someone, you'll never leave them anything. What that means is you're not going to leave it to them in their individual name. Here you go, here's a pile of money. I've seen it too many times over the last 25 years where people inherit and the money's gone. And, we see those problems because we're lawyers and they come back to us and they say, hey, how can I protect this? And the short answer is, look, unless somebody set up a plan before, you can't protect it.
Yeah, absolutely. And I think one thing we're seeing in addition to bankruptcies and divorces becoming more common is alongside that, simultaneously, I think what we're seeing is people are fighting more frequently over inheritances, right? People are accumulating more wealth than ever. They're transferring more wealth, so inheritances are larger than ever. And then I think, and I'm kind of self-admitting this, I think the people in my generation who are the ones who are receiving inheritances, a lot of them have a very entitled attitude. Not all of them, but that seems to exist amongst my generation. You put all those factors together, and you really need an intentional plan that's going to protect this wealth when it goes to your loved ones. So why do I have a picture of a guy jumping out of an airplane here? Well, this is a paratrooper, and he's going to pull that line on that parachute, and that parachute has to open when he needs it to, right? This is a lot like what inheriting with no plan is like. There's really no certainty whether that parachute is going to open properly, right? That parachute needs to have been packed by a thoughtful professional in order to accomplish the goals that we want to accomplish, which is ultimately the parachute opening and working properly, right? That's how we want your estate plan to work and the eventual inheritance that you leave your loved ones. Now, unfortunately, inheriting money is risky. And so what do I mean by that? I don't necessarily mean to imply that the moment you leave an inheritance to your loved ones, they're going to have a red target on their back and people are going to be coming after them. That's not realistic. But what is realistic is after you pass away and they get that wealth, they could have a serious creditor issue, right? They can get in a car accident and maybe there's multiple cars involved and the judge says, hey, you were just a little bit at fault, but the other guy who was actually at fault, they can't pay up. And now you're responsible for 100% of the damages. That's a concept called joint and several liability. It exists in a lot of states. California is one of those states. And I'll tell
Shocker.
you, Jim, when I,
Shocker, right?
yeah. And I'll tell you what, when I was a litigator for 2 years before I shifted my focus on this area of the law, I would see this come up all the time. I'd have a client who was getting sued who really didn't do anything wrong, right? They were just involved in something at the wrong time in the wrong place, and the actual wrongdoer couldn't pay up, and they were getting stuck with the liability. It's really a shame that that happens. But what happens if you leave $1 million to a person who's going through that? That $1 million is going to be at stake? Yeah, you bet it is. What if they have to file for bankruptcy? I mentioned this at the beginning. I think unfortunately, one thing you're going to see as time goes on is the economic consequence of what we're facing right now may lead to an increase in bankruptcies. And if someone gets $1 million inheritance, for example, I use $1 million inheritance, not for any particular reason, but if someone gets a big old chunk of money and they're going through a bankruptcy, you better believe that if it's not properly structured, they're going to have to report that. And the bankruptcy trustee may have complete access to those inherited assets. And then one that is probably the biggest of them all, the biggest risk to an inheritance is divorce, right? What happens? Well, at least in California, which is a community property state, and a lot of the states on the West Coast are community property states. Our laws say that when you receive an inheritance, it starts off as your separate property. So if you're married when you receive an inheritance, it doesn't belong to your spouse. But what happens with most couples is as time goes on, they start to commingle that inheritance. They put it in a joint bank account. They start using it to pay off their joint mortgage. And as time goes on, as they commingle that inherited wealth, the character of that property actually changes. It goes from separate property to community property. And if you get divorced and you own a bunch of community property, Jim, what happens to the community property?
50-50 split, just split right down the middle. And the analogy I would use, I don't know if you remember years ago, there was this commercial on TV that said, and I can't remember what it is. It was the Roach Motel. The roaches check in, but they don't check out. And maybe it was a raid or something like that. So that is kind of how community and separate property works. It is very easy to transmute separate property to community property. It is very difficult to go from community to separate property. It's a one-way street. So we rarely see community property being transmuted to separate property, but we frequently see separate property being transmuted to community property. So what that means is if one spouse inherits the property, it is very easy for a court to view that as marital or community property, and that would be subject to a 50-50 division at divorce.
Yeah, absolutely. And I don't know about you guys, but who here knows somebody who got divorced after years and years of marriage? I think a lot of people, they think of divorce and they think, oh, well, that's something that happens in the first few years of marriage. If my kids have been married for years and years, they're probably at a low risk of getting divorced. I know plenty of people who have become divorced after 30, 40 years of marriage, right? So it's something you always need to be mindful of, even at the time being your loved ones are in a good relationship. So the value of proper planning. So if you're anything like me and you're working very, very hard to accumulate something to leave to your loved ones, I have a daughter and I hope this doesn't happen anytime soon, but I intend to provide for her when I pass away. And if you're anything like me, if I knew that what I worked a lifetime to leave to my daughter one day went to an ex-spouse or it went to a bankruptcy trustee or a creditor for no good reason, I'd be rolling around in my grave. And when I meet with my clients, probably about 80 to 90% of my clients, they express that same sentiment. They say, hey, is there a way that I can leave this to them in a manner that's protected? And the answer, fortunately, is yes. You can protect your loved ones by using what we call a continuing trust. So there are two types of continuing trust we're going to discuss today. And one's called an inheritance protection trust. The other is called a dole-it-out trust. And I like to kind of use a case study to highlight the way these trusts work. So let's take, for example, Bob here. And Bob is a responsible person. He's a doctor. He is the responsible one in the family. But he's having a shaky marriage, and he's in a risky business, right? He's a doctor. He could be sued for malpractice. And because he's a responsible person, I think a lot of people traditionally would say, well, hey, if there's anyone we can leave this $1 million inheritance to, it's Bob, right? He's the responsible one. But what happens if that shaky marriage ends in a divorce and they've commingled those assets? What happens if he is facing a malpractice lawsuit because he was one of the surgeons in the room when another surgeon committed some malpractice, right? So when that happens, all the surgeons are going to be named defendants. And, we may not want to have stuffed Bob's pockets with $1 million if he's going through that. So what's the better way? What's the way you may want to consider to be able to still leave Bob his inheritance in a manner where he can control it and he can access it and manage it the way he sees fit, but at the same time, accomplish a level of asset protection over that inherited wealth? We can use what's called an inheritance protection trust. And Jim, this is what I kind of refer to as modern estate planning, because this is what my clients over the last 5 years or so are gravitating towards. In fact, it's kind of rare that I draft a trust for somebody who's not using this strategy. So how does an inheritance protection trust work? Well, essentially, the parents can structure their trust in a manner to where when they pass away, their trust continues to exist. And it continues to exist for the benefit of Bob. And Bob can be the trustee or the manager of that trust. And if it's structured properly, he can be in complete control. He can have 100% access and 100% management over the assets in that trust. But here's the thing, those assets are not owned by Bob. They're owned by the trust. So what does that mean? It means if Bob has an issue with a creditor or a divorce, the fact that he doesn't own it may actually be better, right? Because if it's in that trust, it can be structured in a manner where his creditors can't have access to it. That's a very powerful thing, right? And I think that's the reason that a lot of our clients gravitate towards this strategy. In fact, when my parents did their trust, I told my parents, hopefully you just spend everything, right? But if you do leave me anything, I hope you consider this, because I would feel more confident knowing that what you worked hard to leave me is protected, even though my marriage is going great, even though I sure hope I never get sued one day. I like the level of confidence I have in knowing that what my mom and dad worked hard to leave me is going to remain safe.
Yeah,
right?
Jeff, it's very, very important to point out that for those of you listening to this, Bob cannot be the one that creates this estate plan. Bob's parents or someone else has to do it, right? So, but typically this is going to be Bob Sr., right? If this is Bob Jr., so his dad, Bob Sr., and his mom, they create in their living trust estate plan, in their living trust, they create this planning mechanism for Bob. And it's not something that Bob can do on his own, but only his parents can do for him. It's very, very important.
Yeah, Jim, I'm glad you bring that up, because probably at least once every 2 or 3 weeks, I'll meet with some children. They're not children, but they're the children of somebody who passed away. And we're kind of well known for possessing expertise in this area of the law. And so the kids will sometimes meet with me and say, Jeff, how can I create a level of protection on this inheritance I just got outright? And it breaks my heart sometimes to have to tell them, well, since your parents didn't set it up this way for you, there's not much we can do to gain that protection. So absolutely, Jim. Now, there may be instances where you intend to leave an inheritance to somebody who may not be as financially responsible as Bob. And you may like the idea of being able to leave wealth to somebody in a manner that's protected, but perhaps that beneficiary isn't quite ready to manage that wealth on their own. And so this is Jane, and Jane needs a little bit of help managing her inheritance. We know that if we leave Jane $1 million and she's in complete control of it, that money may be gone in 6 months, or her influential husband may get his hands on that money and he's going to spend it all partying and buying fancy cars and boats. And so this doesn't change the fact that Jane needs inheritance protection, right? But she may not be the one that manages this wealth. So this is actually based on a real life example. We had a client who came in and said, guys, I have a Jane of my own. My daughter recently inherited my ex-spouse's estate when he passed away. And she got about $1 million, and that money was gone in about 6 months. And my daughter came to me and she says, I don't want this to happen when I inherit your wealth, Mom. And I've been working really hard my whole life, but I've not been able to put aside enough for retirement. And when I eventually get this from you, I'd prefer that there's a structure in place to make this wealth last throughout my lifetime. And so for Jane, our client created what's called a dole-it-out trust. So a dole-it-out trust provides that same level of asset protection, but it also protects the beneficiary from themselves. And the distributions that are made from the trust end up coming more in a stream of income. So perhaps the creator of the trust, Mom in this instance, says, well, hey, I'm going to set up this trust so that the trust provides $2,000 a month to Jane or $3,000 a month to Jane. And the manager of the trust or the trustee of the trust isn't going to be Jane. It's going to be somebody else. Maybe it's going to be her brother, Bob, or another third-party responsible trustee. But a dole-it-out trust is also a popular style of trust to use. And frankly, the longer I practice, the more I like the idea of a dole-it-out trust, because as I practice longer and longer, I actually see how quickly inheritances can be blown. And sometimes you think you're leaving it to a responsible beneficiary, and once they get their hands on that money, their attitude changes and the money's gone like that. So an inheritance protection trust and a dole-it-out trust are two very popular ways of accomplishing asset protection that you can add to your revocable living trust that doesn't require that you do really, really fancy asset protection planning. So how does a continuing trust actually work? Go ahead, Jim.
Well, there's also a slight hybrid to this, which is giving somebody, so some people say, well, I don't want my kid to be in control of the money yet, so I would like it to start out as a dole-it-out, but I would like it to eventually convert to an inheritance protection trust. So for a younger beneficiary, you can certainly say that until this beneficiary reaches a certain milestone, and typically the clearest milestone is age, although age does not necessarily correlate with, responsibility. I think we can all think of someone who's our age and not financially responsible. But I think a parent can create an estate plan that says, listen, until this child is 40 years old, they're not going to be in charge of the money. They're not going to be managing it. But you know what? They can be a co-manager. They can participate. They can have a seat at the table at maybe age 25. And then they have 15 years to educate themselves on a manager. So you might have a co-trustee situation. So there are a lot of different ways to create an estate plan to give asset protection that can be tailored to your precise situation and needs.
Yeah, certainly. So the way these continuing trusts actually work is a grantor would set it up. A grantor would be you, the creator of a trust. You would set up a continuing trust to eventually receive the inheritance that you leave your loved ones. And that continuing trust is going to have a trustee, and the beneficiary can either be the trustee or there can be a third-party trustee. And it's designed to benefit your loved one, right? So when you're setting up a trust like this, there are certain considerations you have to make. Now, I'm trying to keep this kind of at a 30,000-foot level, so I don't want to get too detailed in the considerations that are made. Usually when you have a consultation with a lawyer, these are the things that we would go over. But what's very important is, in light of recent changes to the law, if you draft a trust where there are mandatory distributions, which say you've passed away, you've left this inheritance in a continuing trust, but the trustee must or shall make distributions in a certain period of time, so they have to give out 25% of the principal of the trust each year, for example, that is probably going to blow the asset protection qualities of that trust. So if you have an older variation of these continuing trusts, it was very common to have language like that, to have what we call withdrawal rights. And since the law changed quite recently, you may want to reconsider whether you have that language. I know a lot of clients I meet with who kind of feel confident that they already have this. They come in and show me their trust, and that withdrawal language, which is usually just a couple of lines hidden in the trust language, can blow the whole thing. And you better believe if a creditor sues your loved one, they're going to be magnifying that one or two sentences within the trust. Now, it's typical for these trusts to have what's called a HEMS standard. So trusts generally produce income, which is, the income produced by the trust assets annually or monthly. And a trust will say how much access to income the beneficiaries have. And there's also something called principal. And principal is the underlying asset that exists in the trust. So most of these trusts will say what level of access the trustee has to the principal of the trust. And generally, that trustee is limited to what's called a HEMS standard. And HEMS is an acronym that stands for health, education, maintenance, and support. And so most asset protective trusts have this standard, and they say, look, if you're the beneficiary of one of these protective trusts, you or the trustee can distribute principal from the trust so long as it's for your health, your education, to maintain your lifestyle, or to provide general support. You may distribute principal from this trust, and at the same time, you can have that language and maintain the level of asset protection. So what that means is a creditor can't come in and see that language in the trust and say, well, hey, you can take money out of this trust for any reason. Your Honor, compel them to give it to us. You can make the argument that, well, hey, I'm limited to this HEM standard, and one of the things I'm not allowed to do is take money out of this trust and leave it to my creditor. And that's a very powerful provision.
Jeff, we've got a question from Anita. Anita asks, what's a typical trustee fee? Is it assessed annually? And trustee fees, typically, if you're your own, if you have your own living trust that you set up and you're the trustee and the money's for you, no one's going to take a fee on that. It doesn't even make sense. It's only when somebody is not serving as beneficiary, typically, that there's a fee. So even on like the inheritance protection trust, you're not going to see somebody who's, if they're serving as a trustee, you're not going to see them charge a fee. So typically it's when somebody holds the property as trustee for somebody else. And it really depends on where you live. So where the trustee lives or where the situs of the trust is, oftentimes controls. In California, there is no strict guideline whatsoever. What we do see in certain counties, and it kind of goes by county basis, sometimes we'll see 1% per year for an individual or a private professional fiduciary. Sometimes it's less than 1%. If it's a trust bank, and a trust bank an example would be Wells Fargo. Wells Fargo has a bank, Wells Fargo has a trust company. Those fees can be anywhere from 1% to 3%, depending on the asset. So typically for real estate, they will charge more. And then for trust companies, which is kind of like a Wells Fargo, and we recommend to our clients many times Premier Trust in Nevada, their fees start at 0.65% or 65 basis points. So what that means is 0.65, and then it goes down to 0.3%. So and that's an annual fee. Florida has a law that says if you charge 75% of the probate fee, that is statutorily a reasonable fee, but it's charged once. So that's not so much for a continuing trust, that's more settling an estate. So the short answer is, what most of our clients do, by the way, is they track their time, and there's a certain dollar amount per hour that they charge. And so it depends on the nature of your activity. It also depends on your training. So there's no easy answer. It's all over the map. However, you can specify in your trust, you absolutely can say it's going to be 1% a year, and that's the trustee fee, and you're free to do that.
So what happens if you set up one of these trusts and you leave an inheritance to them, and that person eventually passes away and they haven't used all the assets within that trust? Well, there will be a provision in every trust drafted this way that contemplates that scenario. And you, as the creator of the trust, can put a provision in there that says, hey, if this person passes away and there's assets left over in the trust, then it goes to this next group of beneficiaries who you choose. And it's also up to you whether you grant the original beneficiary something called a power of appointment. And this is different than a power of attorney. This is something called power of appointment. And that simply means if you'd like to, you can give the primary beneficiary of that trust the power to appoint who those trust assets go to next in the event they pass away and haven't used up all of that wealth. So that's a consideration when you meet with a lawyer and consider setting this up. You certainly discuss whether there should be a power of appointment or not for a beneficiary.
Yeah,
an example of where a power of appointment may really come in handy.
Well, I was going to say a power of appointment is best understood as a power to disappoint. So typically what you'll see is the property will go from the child to the grandchild, but the child retains the power to leave that property to his spouse, perhaps, right? Or a charity or other family members. And it's very important. Sometimes that power of appointment will be exercised in a way that gives creditor protection to the grandchild when the grandchild inherits money. Now, there's some tax issues on that, but I think you can see that, you guys have taken a lifetime to create your wealth, and it has meaning and it is valuable and you care. Otherwise, you wouldn't be here. And so, like many of our other clients, you're probably thinking, wow, this sounds like a really good idea to protect this not only for my kids, but also my grandkids. And that's what a power of appointment does.
Yeah, thanks, Jim. Now, another modern provision that you may want to consider putting in a trust with asset protection, and something that enhances the level of asset protection, is a trust protector. And Jim, for people who have never heard of a trust protector, what do they need to know about this?
Well, it's really, we call it the superhero feature, and that was another attorney in our firm came up with this term. Here's the problem. You have a trust and then you die. Okay? We're not getting out of life alive. Everyone's going to die. And either your trustees refuse to serve or they're dead. You may have issues you may need some enhanced creditor protection if you kind of have super creditors that are coming in. And you may need to change the terms of the trust. So what I mean by that, and I'll give you kind of a more basic example. We had a client years ago who came in and set up their estate plan. They wanted to give a ranch that they had in California to one of their kids. Well, the clients ended up moving to Texas and selling the California ranch, but buying a ranch in Texas. And everyone in the family knew that this one child was supposed to get the ranch, whether it was in California or Texas, but the parents never came in to update their estate plan. So typically what would end up happening is we'd have to go to court. We'd have to petition the court. And I'm not even sure we would have been successful on that petition, because the way the trust was written, that one child who should have gotten the ranch would have never gotten it. So very, very important. But everyone in the family agreed. So what do you do? I was actually the clients appointed me trust protector, and I was able to change that provision. And I took out the California ranch and I put in the Texas ranch, but everyone agreed. So a trust protector, and this is kind of important to understand, a court always has power over a trust, always. If a trustee serves as trustee, the trustee has implicitly consented to the jurisdiction of the court. So what that means is any judge anywhere in California can order any trustee in California to do anything or stop from doing something. And so a trust protector, like a court, a trust protector has powers over the trust, but is not the trustee. And what the trust protector does is it kind of pushes the court out of the trust for many, many aspects of handling a trust. And we believe, and many, many other commentators and many other lawyers believe, that this is a much better way because there's a lot more control. And that's really, really important, is you never know what's going to happen when a matter goes before a judge. You don't know the judge. They don't know your family. They don't know the situation. They have to learn. And they're really constrained by the law. With a trust protector, and this is a consensus basis, but the nice thing about a trust protector is they have very broad powers, and that can be really beneficial for the family. And people, most people never use a trust protector, but those who do are really happy that they did, because it's way more efficient to take a case to court in a living trust, at least 10, 15,000 in attorney's fees. There's no way it's going to be less than that. These are very complex cases that involve a lot of people. So a trust protector, definitely, if you're going to have a continuing trust, something definitely to consider. It's what we will likely recommend if we meet with you and we start talking about a continuing trust.
And you mentioned in your example there, Jim, that those clients had appointed you to serve as the trust protector. Now, a lot of our clients, they end up deciding to name our law firm, or they name one of the lawyers at the law firm to serve as trust protector, mainly because if there's changes in the law and those have an impact on your trust, usually the first people to spot it, sometimes the only people to spot it, is the actual trust lawyer. right? So I think that perspective makes us a valuable choice. Now, of course, you certainly, if you're going to have a trust protector, you don't have to name your lawyer. You don't have to name a law firm. You can name another trusted advisor like a CPA, for example. But in our experience, we're named quite frequently as a trust protector for our clients, and we're proud to do that. So a lot of people I meet with, they don't just have one asset, right? They have a combination of different types of assets in their portfolio. They have a life insurance policy, they have a house, they have an annuity and an IRA. I would suspect that a lot of you who have joined us today have some kind of retirement account in place, whether it's an IRA or a Roth IRA or a 401k or a 403b. And how does asset protection work for all these different assets? For example, can you create an inheritance protection trust for your beneficiaries and take all these different types of accounts and funnel them through there? Well, there's a way to create an asset protection strategy for each one of these assets, but you may not be able to do it by just using one trust. You may need to create a special type of plan for the respective type of asset. So for example, with IRAs are fantastic. They allow you to save up retirement wealth. You can defer paying the income tax on it. I think right now in the history of America, we've never had cumulatively more wealth saved up in retirement accounts. For a lot of the people I meet with, this is their primary asset, sometimes even more valuable than their home or the equity in their home. And so this requires special planning. We recommend for a lot of our clients we meet with something called an IRA legacy trust. And a legacy trust is essentially a carefully crafted plan that exists to provide a structure for the retirement wealth after you pass away, to funnel it to your beneficiaries in not only a tax efficient manner, but a manner that's protected from creditors. So several years ago, there was a landmark Supreme Court case. You'll see I cited it in this slide. And without getting too boring talking about the Supreme Court and their recent decisions, what happened in the case is a woman passed away. She left a sizable IRA to her daughter, and daughter lives on. She has this IRA, and this is amidst the financial crisis, and daughter has to file for bankruptcy. And the daughter says, well, Your Honor, I want to participate in this bankruptcy. I want to pay my creditors as best I can, but IRAs are protected by law from creditors. And generally, when people get sued, their IRAs are protected. And so this issue went all the way up to the United States Supreme Court, and the justices voted 9-0 unanimously, which doesn't happen that frequently, that the new rule going forward would be when somebody inherits an IRA and they're not the spouse of the original owner of the IRA, there's no longer asset protection associated with that IRA. So in this case, the poor woman had to take that money from the inherited IRA. She had to pay off all of her creditors. And in order to do that, she had to take all the money out of the IRA. Now, folks, when you take money out of a traditional IRA, what do you have to pay on it? Income tax. So this was a double whammy. She had to pay tax on all this money and also had to give all of it away. And so why do I tell the story of this case? Well, today, one of the only ways to preserve asset protection on IRA monies that you leave to your beneficiaries is by using an IRA legacy trust. So for a lot of our clients who have sizable IRAs, and frankly, I would say about $150,000 per beneficiary is what I would consider a sizable IRA. You may want to consider an IRA legacy trust. It's one of the only ways to ensure that once you're gone and those accounts transfer to your loved ones, that they're continue to be protected from the creditors, from a divorcing spouse, from a future bankruptcy.
And Jeff, we had a question from Susan. She says, for the traditional IRA or 401k money, can you put it into a dole it out trust so it does not need to be taken out in 10 years? The answer is yes, but there's a little twist on this. So there was a new law passed in December that said all the money has to come out of an IRA in 10 years if you inherit it, as a general rule, okay? Spouses are different, but as a general rule, you don't have to take any money out for 10 years. And in that 10th year, on that New Year's Eve, December 31 of 10 years after your death, at 4:59 p.m., all the money has to come out, right at the close of business. All the money has to come out. You can put an inherited IRA into an IRA legacy trust, And what you can do is you can say, listen, when all that money comes out of the IRA account, that money stays in the trust so that the money's not distributed to the beneficiary. Now, I will tell you, probably 90% of IRA legacy trusts before December of 2019 were written the following way. The trustee shall distribute all minimum distributions over the beneficiary's lifetime. There were a lot of reasons why that was a better plan. It used to be that you could stretch these IRAs out over your entire lifetime. You know, if you're 50, it goes until your mid 80s. The new rule is at 10 years, all the money comes out of the account. The problem with the older legacy trusts is 90% of them say you have to distribute that money when it comes out, and that may not be the best thing for the beneficiary. It may not be the best thing for taxes for a variety of reasons. By the way, a little sweetener on this, we typically recommend that people use a fiduciary outside of California, preferably Nevada, South Dakota, Tennessee, or Alaska, because those states have no state income tax, right? And we're at least at the moment able to delay the payment of state income tax, hopefully as the law develops, which I think that's the way the law is going to end up. There are a few cases working their way through the Supreme Court right now that stand for the proposition that if your IRA legacy trust is in Nevada, you don't ever pay California income tax. So that's a big bonus, something really to pay attention to.
A lot of my clients also have annuities, and there are several different types of annuities. If it's a retirement annuity, it may be appropriate to put that type of annuity into an IRA legacy trust because they're very complex. Well, we certainly recommend you come in and meet with us. And usually it's not uncommon when I have a meeting with somebody that I have a policy statement of every one of their assets, right? So I have a statement from their annuity, I have a statement from the IRA or the 401k. And with all that information, we can determine what asset you can put in here. So I see that there was a question from Anita. You asked another question. Can you put other types of assets in an IRA legacy trust, or is it only for an IRA? The answer is it's not just for an IRA. You can put other types of assets in there as well. So life insurance. I don't know about you, but I love having a life insurance policy. In fact, one of the proudest days of my life was when I bought my first life insurance policy. It felt like the first step I was taking towards really protecting my family in case something happened. And one thing you can do with life insurance, if you're considering an inheritance protection trust, is with life insurance, it has a beneficiary you designate. So when you pass away, the life insurance company looks at that form you filled out to see who inherits the life insurance policy, who are those proceeds payable to. One thing people who set up inheritance protection trusts may want to consider is naming the trust as the beneficiary. So if there's a $500,000 proceed that pays out from the life insurance policy, perhaps you can get those proceeds into that protective trust and protect an even greater amount of wealth by using that trust, right? Now, Jim, I've heard people talk about irrevocable life insurance trusts. Do those provide a level of asset protection? Is that a strategy that can be utilized for that?
Yeah, they can. You know, typically they were invented or developed by lawyers because the amount of wealth that you could leave a beneficiary used to be very low. It used to be $60,000, and then in the early 1980s, that was raised to $600,000. And so what people would do, you know, if you had a $3 million estate, that estate pays $1 million in estate tax. Well, if your sole asset is the family home, you're like, well, we can't really sell a third of the family home and we want to keep it in the family. Many people would go out and buy a life insurance policy. So for $1 million. The problem with life insurance, even though there's no income tax on it, you have to pay estate tax on it, right? So if you had a $3 million estate, and you went out and you bought a $1 million life insurance policy, well, now you have a $4 million estate. And so now it's just not efficient. So what people did is they would buy life insurance in a special irrevocable trust, and you can build creditor protection into that irrevocable trust. Something that you need to be mindful of, and I see the list of the names of the people who are attending here, and I know some of you guys likely have a life insurance policy, an older policy. We're doing a webinar tomorrow, or a virtual workshop tomorrow on long-term care planning. One thing that we're seeing a lot of clients do is if they have an older life insurance policy, they're either repurposing that policy for long-term care insurance, which is really great, or they're doing an exchange of that policy into a new policy. And the reason is life insurance in the last 20 years has gotten significantly cheaper. So many of our clients are able to take their existing permanent policies and exchange those for newer policies, and either the coverage goes up, and in many instances, if they're making a premium payment, that goes away. So very, very important. I would highly encourage you to talk to Jeff about that if that's something that you're interested in.
I'm going to go over two other strategies that are cool and creative when it comes to asset protection. And the first is called disclaimer planning. So what is a disclaimer? This is when somebody who stands to inherit intentionally says, I don't want it. I'm not going to take this inheritance. Now, why on earth would anybody say that? Well, let's say I stand to inherit $500,000 and I'm in the middle of a lawsuit. And my parents didn't set up an inheritance protection trust for me. Or maybe they did, but I want to make sure that my creditors really don't get the opportunity to get that money, because I know in this lawsuit, I didn't do anything wrong, right? And I think a lot of creditor protection is not necessarily to circumvent liabilities that are legitimate. I think a lot of the reasons we do this is because there's a chance that if you get sued, it's going to be illegitimate. Someone's just coming after you. There's a predator out there who is going after you, right? We have a client who had a bad tenant. They caused a lot of trouble. They evicted the tenant, and a few months later, they were served with a black mold lawsuit. I don't know if you've heard of those, but those are multi-million-dollar lawsuits, and this was done purely in retaliation for being evicted, and it was a lawful eviction, right? And so for people who just really want this additional level of protection, they may say, hey, I don't even want this inheritance. I'm going to do what's called a disclaimer, and I'm going to allow the next person in line under the terms of that document that was providing the gift to govern who gets it. So, my parents are going to leave me an inheritance. I'm going through a lawsuit. I say, I'm going to exercise this disclaimer. We're going to look at who the backup beneficiary is. It's my daughter, and then my daughter is going to receive that inheritance. I may do that strategically. Now, when it comes to a disclaimer, there are some pretty technical rules, and I think this is rarely done, right? A lot of people, it takes a lot of guts to say, hey, I'm giving up my inheritance altogether, or a portion of my inheritance. But sometimes it makes sense to do that. And if you're considering doing that, there are time constraints. There are certain procedures that have to be followed. There are certain state law considerations. So it kind of depends on what state you live in, whether you can do this or not. But this is something that is certainly worth discussing with a lawyer if there is a creditor issue that has arisen. And finally, we're going to discuss a rather newer concept in California. Overall, not a brand new concept, but for California, we've recently adopted this. Jim, talk a little bit about decanting, if you will.
Yeah. So the reason there's a picture of wine there, is it wine time? No. So the reason there's a picture of wine is that's what you do with certain wines is you decant them, you move them from one vessel to another. And so the idea with decanting in its most basic sense is you take assets from one trust and you set up another trust and move those assets to the other trust. Now, prior to very recently in California, there was no statutory basis for this, but the state of California passed this law that says you can decant a trust. You can move assets from one to another. And this makes sense because I've got a client who's the beneficiary of a trust written in 1933. Some of these get old, they get a little clunky. You really do need some more modern features in these trusts. So decanting permits you to move assets from one trust to another. It also permits you to move the situs of a trust from one location to another. What do I mean by that? Well, the situs or location, just like construction site, well, situs is the Latin word. It means location of the trust. If a trust is in California, it is subject to California income tax. If you move the situs to Nevada, it stops being subject to California income tax. So you run the numbers and you go, yeah, it might make sense to move this trust to Nevada or not. It just depends. But this is a new, very powerful tool that is really a great benefit. Like any tool, it's a great benefit if you need it. If you don't need it, then then it's just words on a paper. One thing that is important, though, is you cannot materially change who gets what. So this isn't like a thing where you can change the beneficiaries. The same people are the beneficiaries. The same people are the same people who are inheriting, but we're able to have a lot of extra protection for beneficiaries is the bottom line.
Certainly. Now, most of our presentation today has been focused on how do you provide asset protection to your loved ones, right? How do you protect an inheritance that you're leaving to another person? But there are also strategies you can utilize to develop an asset protection plan for yourself to protect your own assets while you're alive. And a private retirement plan is something that we recommend a lot of the people we meet with consider. How do you protect your own assets, Jim, by using this?
Well, California in 1970 enacted a statute that said Californians, and this is just, a lot of people complain about California. We have great weather and we have private retirement plans. I think those are the two big bonuses of living in California. This is a law passed in 1970. It was the precursor to ERISA, which was passed in 1974, which gave us 401ks and IRAs and all these great planning strategies. ERISA, the federal 401k statute, gave a sweetener of tax advantage. Now, the California Private Retirement Plan has zero tax advantage, but here's what it does allow you to do. It allows you to calculate your retirement needs, and it allows you to set aside assets to fund your retirement. And this provides you with proven creditor protection. Now, I will tell you, most asset protection strategies are hardly ever litigated in court. The example I gave of the lawyer being sued, that hardly ever happens, okay? Most people settle. So there isn't a lot of law on it, but there is a lot of law on private retirement plans for a variety of reasons. And there are ways to set them up properly, and there are ways to not set them up, right? There's a right way and a wrong way. You have to make sure that you do it the right way. We do have an asset protection virtual workshop coming up. If this is of any interest to you, I highly recommend that you RSVP yes on that. And I think we'll be sending out reminder emails for this. And Jeff, we should probably send out an email to the two upcoming webinars that we're talking about.
Yeah, I encourage all of you to attend that because this is a really cool strategy, and there are more strategies that exist in addition to this. When I was in the civil defense side of law, I represented a lot of contractors, a lot of real estate developers, people that were kind of in high-risk professions. And my gosh, if I had known that these private retirement plans existed back then, I would have had every single one of them do this, and they would have been chomping at the bit.
Especially Jeff, especially now because so many businesses are under strain, and I've been paying attention. I've been doing a lot of webinars, and the general consensus is if you don't have enough cash to get you through the end of the year, when things start to go back to normal, whatever that means, right? But if you don't have enough cash to get you through the end of the year, like if you run out of cash in your business in August, you need to make a really tough choice now. Is do I dip into my personal funds and fund that business, or do I shut it down and do something else? So I think there's going to be a real significant spike in lawsuits, and people, when the economy goes down, people are looking for money. And if you have money, you're a big target. If you don't have any money, people who don't have money, frankly, don't get sued. I know that it's a sweeping generalization, but it's really only the rich people that get sued, or the people with money. I do want to mention one thing. I'm putting this in the notes. Here's a link to my book, Savvy Estate Planning, What You Need to Know Before You Talk to the Right Lawyer. It's available on Amazon. I highly recommend that you guys take a look at that. And I think it's like $15 or something on Amazon, but it's available on Kindle and audiobook. And there's a question here from Agnes. Is a private retirement plan applicable for someone who already has a 401k and IRAs? Yes. This is very, very important. Agnes, I am so thankful you mentioned this. 401ks are protected from creditors. IRAs are not. They're state specific. In California, it's about $1.2 million per person on an IRA exemption, meaning you can have up to $1.2 million-ish, but the judge ultimately decides. And here's the problem. That's bankruptcy. We mentioned bankruptcy. You can only go through bankruptcy if you're bankrupt. If you have a $2 million IRA and you're getting sued for $1.9 million, your petition in bankruptcy is not going to be approved. You will not be going through bankruptcy because you're not insolvent. Okay, so this is very, very important. This planning strategy can protect your IRAs. Very, very important. 401ks don't need protecting. O.J. Simpson allegedly, right, killed his ex-wife and her boyfriend, right? We all know he was found liable. The Goldman family and the Brown family have not been able to recover against O.J. Simpson because he's got like $25 million in his NFL 401k. They can't get it. They can't touch it. Protected from creditors.
So if you're watching this and if you're the kind of person that says, hey, you know, I'm working really hard and this protection stuff is important to me. I want to be able to leave a positive legacy. I want to be able to create wealth that lasts generations to come. Make an appointment with us. You've taken the first step towards getting this done. You've done a fantastic job. My job, Jim's job, is to make sure that your estate plans look like this, right? We want those parachutes to open properly. We want your beneficiaries to be safe. So what do we want you to do? What do we encourage you to do? Take us up on scheduling a free, no obligation consultation with us. You can meet with us from the safety of your home. We're doing most of our meetings on Zoom right now. We're doing video conferences. We're working from home. We're working at the office if it's safe to do so. But what do? At the end of this presentation, you're going to get an email for an invitation to set an appointment with us. I recommend you set it today, because if you don't, what happens? Life goes on, you go on to the next thing. This stuff starts to slowly melt away from your mind. If you've been watching this, if you stuck around until now, you probably understand how important this is, and get this done, right? Meet with us. We're very friendly. And how do you do it? You make an appointment. And number two, you show up for the appointment, right? And if you're married, your spouse should be there because you probably own your assets jointly together. The exception to this would be if you guys keep your assets completely separate, then it's appropriate for us to meet with one spouse. But we're going to open up for a quick Q&A. You guys have done a great job of asking your questions throughout, so I don't suspect there are going to be too many questions here. But we're going to stick around for a couple minutes. If any questions pop up, we're going to answer them. And if there are none, we're going to sign off.
Maybe there's somebody typing really fast. You know, I can
certainly
open
don't.
it. For those of you who want to talk, I can open it. You want to try this? Do you want to allow everyone to talk? Or raise your hand if you want to talk? Oh, it looks like, here we go. So we can read this. Can an ILET beneficiary be changed? Ooh, good question. Sometimes. If no one's dead, generally. Even if someone's passed away, you can change it, but you might have to go to court for that. But generally, if everyone's alive, you can change it. You can modify an irrevocable trust, but you can't amend an irrevocable trust. It's a very lawyerly answer. Richard asks, how does this relate to existing living trusts? I don't know if you can be a little bit clearer. Here's what I will say. And Richard, if you want to clarify, that's fine. If you have an existing living trust and you're like, wow, this stuff sounds really cool. How do I even incorporate this into my living trust? What we typically do with clients, in fact, most of our clients already have a living trust. Jeff, I don't know what percentage of your clients, but pretty much everyone I meet with has a living trust. We do what's called a restatement. So my living trust is called the Cunningham Trust, dated March 20th, 1998. I've restated that trust 3 times because we've adopted 2 daughters and my kids have gotten older and now they're adults, and I've just felt that the estate plan needed to get changed. So I've changed that estate plan 3 times. I've done 1 trust and 2 restatements. That's where you take all of the terms of the trust, you throw them in the shredder, you start with a new trust. That is typically with most truly experienced lawyers are loath to amend a trust. They would much rather prefer to do a restatement, because when it comes time to administer these, there's a trust and 6 amendments. It's frankly hard to figure out what's going on. Let's see. So can it be changed to another trust? That would be decanting. So Can an ILET beneficiary be changed? Can it be changed to another trust? Perhaps. I would suggest that you set an appointment with Jeff and go over that with him. But I would say, generally speaking, yes, that's certainly a possibility. And Susan asks, how much do you charge to serve as a trust protector? I do not charge to serve to be named as a trust protector. And generally, in the trust administration process, what I'm doing is I'm signing a document that is the very tail end of some type of activity in the trust administration. And I think sometimes I charge hourly. Jeff, I can't remember if I've had to even serve as a trust protector on one of your trusts. Oftentimes I'm just signing a document and I'm not charging the client. But there is work to be done to figure out what to do, if that makes sense. So the trust protector, it's kind of like a court order in a sense. And oftentimes these documents are 1 page long. It's literally turning a screw on a paragraph, if you will, changing an and to an or, perhaps. So I'm not so much charging for that. Kay asks a question. I am the custodian of several small UTMA accounts for the great-grandchildren, and it looks like you got cut off. So an UTMA account is an account that typically gets paid out when the children reach a certain age, for example, 18. Once they turn 18, they're entitled to the money. Can you keep it secret if they're irresponsible and not tell them? Yeah, I suppose you could. But, what those are designed to do is they're designed to be held as an alternative to a guardianship, which is about a $10,000 process to get started. It's an alternative to a guardianship for money. Anita says, thank you. Well, thank you, Anita. And Agnes says, for married couples, do they need 2 separate IRA legacy trusts for their own IRAs? The answer is yes, because the IRA legacy trust is a planning strategy that stems from a private letter ruling. And the IRS, private letter ruling is something the IRS says to one person, hey, this works. Here's the deal. The IRS is federal. I think 8 states are community property. Most other states outside of California and those other 7 states, most people, when they do a living trust, they actually do separate trusts. So kind of the default in the United States is to do one person, one trust. For that reason, if you're married, you have 2 legacy trusts, but likely only one will be used. Most of our clients leave their IRA to their spouse, and the door swings both ways, right? It's only when that surviving spouse dies that the IRA trust is actually funded, or that assets actually go into the IRA trust. Well,
and I would
yeah.
I would say really quickly before we wrap up, Agnes, one clarification there is I meet with not a lot of clients, but clients who do have IRA legacy trusts drafted from other lawyers 6 years ago. And for some lawyers, it was a common practice to just draft one IRA legacy trust, maybe for the husband. A lot of times it would be for the husband. That's just the way I see it most frequently. And the idea was, well, hey, great, if the husband dies first, we have this plan. But if the other spouse dies first, then we can just meet with that spouse and we can create a new plan after the first death. The problem with relying on that strategy is what happens if one spouse dies and the other spouse isn't doing well, right? Maybe the surviving spouse has Alzheimer's or some health issues, and they can never put a plan in place. So for that reason, or that's one of the reasons, I like using 2 separate trusts for each spouse. But that's a great question.
And
you want to wrap it up, Jim?
Well, hold on. Kay has one more question. I want to resign as custodian. Their parents have not responded to my written letters asking them to be appointed custodian. That is something, Kay, I think you should call and talk to Jeff about. I would suspect that the institution would have an answer. I don't know that you can resign. You may not be able to resign. That, on the other hand, you may be able to appoint somebody else. And depending on the size of the account, you may be able to appoint what's called a private professional fiduciary, which is somebody who, I mentioned trust banks and trust companies. There are some people that have as their profession, they're essentially professional trustees. If the bank will allow you to move that to a professional trustee, they do charge a fee. I don't know if they could even collect on this, but I think it's something that I would put a call in, set a time to talk to Jeff, and then we'll be able to help you out on that. So my thinking is you should be able to resign. Worst case scenario, you could theoretically abandon the property, and then it would go to the Secretary of State. There's the California lost property. I don't know if any of you have checked that out. We should do a whole virtual workshop on California lost property, Jeff, because it's pretty cool. You can.
I look it up all the time. No one's left me anything.
My son, who's now 24, he got a $400 refund on an auto insurance policy when he was about 18. I said, Nick, you're signing this check and giving that money back to me because I paid that policy. That's my money, even though it's in your name. So it's worth checking out. Oh, we have more questions. Tina says, name of the book that is on Amazon. I put that in the comments section. It is Savvy Estate Planning, What You Need to Know Before You Talk to the Right Lawyer. So I'll hold that up, Savvy Estate. If you just Google Savvy Estate Planning, it'll pop up. And what can I do? Kay, what you want to do is call the number on your screen, that 866-988-3956. Make an appointment, and we can help you out on that. And Kay says, thank you. All right, we're going to end it. And Jeff, great job. Thank you so much, everyone, for sticking around. It looks like all of you are diehards, and you stuck it to the end. So,
yeah, this was a very engaged crowd.
Great. All right, have a great day.
Bye, everybody.